Hi everyone, I am Suyash and today I will talk about the case of Y versus State of Rajasthan, wherein the Hon'ble Supreme Court discussed the important factors that ought to be considered while deciding an application for grant of bail. Before understanding such important factors, it is important to note that A. Section 439 subsection 1 of the Code of Criminal Procedure enshrines the power of the High Court and the Court of Session to grant bail. B. Courts other than the High Court or the Court of Session may grant bail in case of non-bailable offences under Section 437 of CRPC. C. Anticipatory bail or bail to persons apprehending arrest may be granted by the High Court or the Court of Session under Section 438 of CRPC. And D. A High Court or a Court of Session may direct for cancellation of bail of any person under Section 439, subsection 2 of CRPC. In the present case, the court concerned itself mostly with the provisions of Section 439 of CRPC, and in this regard, the court discussed the following factors that are to be considered while deciding an application for bail. A. Prima facie ground to believe that the accused had committed the offence. B. Nature and gravity of accusation. C. Severity of punishment in the event of conviction. D. Danger of the accused absconding or fleeing if released on bail. E. Character, behavior, means, position, and standing of the accused in the society. F. Likelihood of the offence being repeated. G. Reasonable apprehension of the witnesses being influenced. And H. Danger of justice being thwarted by grant of bail. According to the court, the aforestated factors ought to be considered while deciding an application for bail. And though the High Courts have been bestowed with considerable discretion while deciding an application for bail, yet such discretion is not unfettered, and the courts must apply its judicial mind properly without being cryptic or mechanical. Further, with respect to an application for cancellation of bail, the court explained the following important guidelines that must be kept into mind. A. Whether the accused has misconducted itself by violating the conditions of bail or due to some other supervening circumstances. B. Whether the order granting bail has taken into account the relevant factors while deciding the same. C. Whether the order granting bail is based on extraneous or irrelevant considerations, making it unjustified, illegal, and perverse. Based on answers to such questions, the court may decide whether to cancel bail or not. Apart from the aforementioned points, the Hon'ble Supreme Court also discussed some general principles that ought to be followed while deciding grant or refusal of bail. They are A. At the stage of granting bail, a detailed examination of evidence and elaborate documentation of the merits of the case is not to be undertaken. B. In bail orders, there is a need to indicate reasons for prima facie concluding why bail is being granted, especially in case of serious offences. And C. Many a times, the courts simply observe that, based on the record or facts and circumstances of the case, they see it appropriate to grant bail. However, merely recording having perused the record and on the facts and circumstances of the case does not subserve the purpose of a reasoned judicial order. Judges are duty bound to explain the basis on which they have arrived at a conclusion. Thus, the aforestated canons or principles of law must be followed while considering applications for bail, failing which any grant of bail may be cancelled by the higher courts. I hope that the relevant factors for grant as well as refusal of bail are clear by now. Hence, I hope you enjoyed listening to the show. Thank you for listening. Please do not forget to like, subscribe, and comment. See you next time. Till then, stay tuned.